Hello, welcome to my channel. My name is Katie and this is where we discuss true crime, politics and current affairs. Today we're going to continue with the coverage of the case of Kouri Richins. If you're new to the case, Kouri Richins died on the 4th of March 2022. His wife Kouri was then arrested on the 8th of May 2023 on charges of aggravated murder and various illicit substance charges. Kouri is currently sat in jail in Utah with no bail. Kouri is presumed innocent until proven guilty at trial, and please remember that there are children involved in this case. But today we're going to discuss that the prosecution requested some medical records about Kouri and the defence filed a motion to quash this. We're going to go through the motion that was filed on the 11th of June 2023 to see what it says. I am going to be reading it for the first time along with you. I'm not sure what's in the motion, so potentially there could be descriptions of medical procedures, medical illnesses, etc. So be warned just in case you don't like to hear about that sort of thing. And if you're new to the case, there's a whole playlist over on my channel. There's a lot going on. Not only the criminal case, but there's a lot of civil cases circling it as well. I apologise for the bad lighting. It is grey, as usual, here in the UK, so I'm doing my best. But without further ado, we will go into the motion, and don't forget to like, subscribe, comment on this video. It is our way of placating the YouTube algorithm gods. So let's have a look-see, shall we? By the way, do you like my cardigan? It's got mushrooms on it. I really like this cardigan. I need to put pockets on it though, but I'm getting distracted. Let's get back to the motion. ADHD. Right, okay, so there we go. Okay, so as I said, this was done back in June. I think it was June. So let's see. And it's filed by the attorneys for the defendant in the case of the state of Utah versus Kouri Richins. And again, the judge is Richard Mrazek. Apologies if I'm saying that wrong. I know I say that every episode. And this is a motion to quash the subpoena to Park City Medical Center. Defendant Kouri Richins, through her attorneys, moves this court for an order quashing the state's subpoena to Park City Medical Center. And this is the introduction. On or about September the 12th, 2023, and or September the 13th, Miss Richins was transported to Park City Medical Center. On the 15th of September, the state filed their notice of return of service for subpoena to Park City Medical Center, compelling the production of medical records of the defendant. The defendant's medical records are protected by the physician-patient privilege outlined in Rule 506 of the Utah Rules of Evidence. Because the state cannot establish a legitimate exception enumerated in Rule 506, the court should quash the state's subpoena and exclude any evidence obtained pursuant to it. So this is the background. As we said, on September 12th or 13th, Kouri was transported to Park City Medical Center. Neither counsel for Miss Richins nor her emergency contact were contacted by the jail, notifying them of any medical incident. Following her return to the jail, Miss Richins was placed in observation until approximately 3:30 the following day. Observation equates to Miss Richins being placed in an extremely small cell without any windows and a small mattress on the floor. Oh, that's a bit harsh. Oh, considering she's presumed innocent right now and she's just come back from hospital, that's a bit harsh. Miss Richins was not allowed to make any calls, including to counsel, despite her request to do so. Following her release, Miss Richins made counsel and family aware that she had been to the hospital. On September the 15th, 2023, the state filed the subpoena to Park City Medical Centre seeking medical records of Kouri. The accompanying subpoena specifically requested the following: any and all medical records, including X-ray images, physician notes, reports, test results of any blood drawn, prescribed medications, etc. Kouri Richins from September the 12th through September 14th. Miss Richins has not consented to the release of any information from Park City Medical Centre to the Summit County Attorney's Office. And this is the defence's argument. So, the medical records sought by the state are protected by the physician doctor-patient privilege and are not recognised under any enumerated exception. Therefore, the subpoena should be quashed and any records produced in response should be suppressed. The medical records sought by the state are protected by doctor-patient privilege. Is it just me, or do these law motion things just repeat themselves constantly? Anywho. In this case, the medical records are protected by doctor-patient privilege, and they are quoting the rules of evidence here. A patient has a privilege during the patient's life to refuse to disclose and prevent any other person from disclosing information that is communicated in confidence to a physician or mental health therapist for the purpose of diagnosing or treating the patient. This applies to diagnoses, treatments, information obtained by the examination, information transmitted among a patient, a physician or mental health therapist and other persons who are participating in the diagnosis or treatment under the direction of the physician or mental health therapist. And that includes guardians, family members, etc., who may claim the privilege. The privilege may be claimed by the patient or the guardian or conservator of the patient. The person who was the physician or mental health therapist at the time of the communication is presumed to have authority during the life of the patient to claim the privilege on behalf of the patient. Okay. Ooh. And the privilege belongs to the patient, enables a patient to prevent a physician from disclosing information. The privilege applies regardless of the stage of the proceedings, and thus it applies even in a criminal investigation. Notification is required to provide the patient with an opportunity to assert the privilege and to assure that the patient can pursue the appropriate procedural safeguards in court to avoid unnecessary disclosure. As enumerated in the comments to Rule 506, the Supreme Court requested that the scope of the privilege be broadened to include information obtained by the physician or psychotherapist in the course of diagnosis or treatment, whether obtained verbally from the patient or through the physician's or psychotherapist's observation or examination of the patient. The court further requested that the privilege extend to diagnosis, treatment and advice. The patient is entitled not only to refuse to disclose the confidential communication, but also to prevent disclosure by the physician or psychotherapist or others who were properly involved or others who overheard without the knowledge of the patient the confidential communication. Okay, we're almost there. Further, the patient is entitled not only to refuse to disclose the confidential communication, but also to prevent disclosure by the doctor or anyone that accidentally overheard or intentionally overheard. The state subpoena compels the production of any and all medical records of Kouri from the 12th September through to the 14th. There exists no question that the records sought by the state are the medical records of the defendant and are therefore protected by doctor-patient privilege. The production of records compelled by the state subpoena are not recognised under any enumerated exception. Therefore, the subpoena should be quashed and any records produced in response should be suppressed. The right of the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, particularly describing the place to be searched and the person or thing to be seized. It is well settled by Utah courts that defendants have a privacy interest in the potentially privileged medical records sought by the state. Further, pursuant to the Constitution, the evidence obtained through the state's illegal subpoenas must be suppressed unless an exception to the exclusionary rule applies. The evidence obtained... So have the state actually got these medical records? I don't know, I haven't looked, because, I'm a professional like that. But a subpoena technically isn't illegal, I suppose. Is whether or not it's enacted. I don't know. I am not qualified. Do not take my legal advice. Do not take my advice, full stop. Anywho. Exceptions in the rule are enumerated and create a limited waiver of this privilege. And then there's a lot there. I don't think there's anything specific to this case. No. There isn't. It's again just quoting various rules, etc. So there's no privilege existing in the proceeding in this regard. Here, Miss Richins, like the defendants in the case mentioned, has a privacy interest in the privileged medical records sought by the state. Based on the general rules set forth herein, the subpoena issued to the medical centre for Kouri's medical report should be quashed, and any evidence obtained pursuant to it should be excluded. The state's use of its subpoena power in this case is illegal on the basis it seeks privileged medical records of the defendant for no legitimate purpose. Specifically, the state cannot make a compelling argument that the records sought fall within any enumerated exclusion. These medical records do not relate in any way to the charges pending against Kouri. Further, Kouri has not been accused of any wrongdoing resulting in her medical treatment. Thus, under Article 1, Section 14 of the Constitution, the court should grant Miss Richins' motion to quash and exclude any evidence obtained through the state's legal subpoena. For the foregoing reasons, the court should quash the state's subpoena and exclude any evidence obtained pursuant to it. And then that was submitted on the 11th of June 2023. And that's just certificate of service, and then it's empty. So, do you know why she went to a medical centre? I don't. I haven't. I could Google it. I may do. I don't know. Perhaps. But according to the defence, there is no reason for the prosecution to need this information. It has nothing to do with the case. Which I suppose could be true. And it is bad that they didn't give her a proper bed. Again, she is presumed innocent even though she is in jail. Yes, she's in jail with no bail because she may be a threat because of the charges she's got. But she should still be able to phone someone. Anyone. I believe it has been alleged, potentially by her brother, that the jail are not administering Kouri's medication correctly. Maybe that's what this is about. Maybe that's why she had to go to hospital. I don't know. If you do know, please let me know in the comments. I will go rummaging around the internet if you tell me where to go. But yeah, this is a lot. So I'm going to see if I've got the state's request for the medical records. And if I have, that will be my next video. If that's not my next video, then I don't have them. If you're interested in this case, please subscribe so you never miss an episode. I know I upload sporadically, but that is because of my health conditions. If you want a pity video, self-pity video on that, I will do it. Let me know. But otherwise, that's it. Thank you for watching. I really do appreciate your time. Let me know where you came from. How did you find me? Are you from the Reddit community? Are you from the Facebook community? If you are, thank you for joining me. If you're from the Reddit community, you know how much this means to me, your support. And you can go follow me on all the socials. It's a bit more political over there. But this channel seems to be focused on the Kouri Richins case right now, because my ADHD brain cannot focus on anything else because there's so much in this case. So like, comment, subscribe, never miss an episode. Subscribe to me over on the socials, and I will stop talking and I will let you carry on with your day. Oh, I pushed a button. I will let you carry on with your day. Thank you. I really do appreciate it. And I will talk to you soon. Bye.